Sorry
All
about
right.
that. I had my sheet printed out, and I probably added this case afterwards.
All right. Mr. Brown is now present. He represents, I believe, Miss Jacoby Radke. Is that correct, Mr. Brown?
It is.
All right. She is present with us today. I still do not see Mr. Matisse on behalf of Douglas Brown, and Douglas Brown does not appear to be with us as well.
Uh, Your Honor, I'm so
Yes.
sorry to interrupt. I have not spoken with Mr. Larry Brown at all, and I had no idea he was going to be representing me today.
All right. If something comes up where you need to speak with him during the hearing, we can put you in a breakout room so that you can do that. And I'm sure that he will want to speak with you after the hearing as well. This is one of the first, and it's a preliminary hearing, so it's not unusual because of the time limitations for that to occur. So I'm sure that he'll speak with you afterwards. Anything that you want to do right away, Mr. Brown, or can we proceed without that?
We can proceed without that. If she needs to speak with me in a breakout, I can do that as well.
Right.
I don't think I would need very long.
All right. Thank you. All right. It does appear that everyone has received proper notice. Court file has notices of today's hearing going out to, including all the parties that are present, including Douglas Brown, who is from Fair Oaks, California. That notice went out on March the 30th. Nothing has been returned to the court that indicates that he did not receive that. It also went out to his attorney, Gabriel Matisse, out of Harbor Springs. So I'm prepared to proceed today on preliminary examination, or excuse me, preliminary hearing. Just for everybody's information, a preliminary hearing is one of the first hearings. It's simply a determination of making sure that everybody understands what their rights are, make sure that the attorneys have been appointed, and that everybody is starting the process appropriately, and making sure that we know what whether or not the petition will be authorized today. Ms. Radke and Mr. Tingley, I apologize for the mispronunciation. You have the following rights: the assistance, the right to an assistance of an attorney, the right to have a trial by a judge or by a jury, the right to admit or deny the allegations, and the right to be heard on whether or not the children should be placed with you or with some other member of the family, and then a determination of whether or not to authorize the petition. As to all of those things, do all of you, Mom and Dad, do you understand the rights that I've just explained to you?
Yes, Your Honor.
Yes, Your Honor, and I would love the opportunity to make a statement when it is convenient for the court.
Your Honor, I would like to speak with her before she makes a statement.
I don't need to speak with Mr. Brown.
All right.
I would like to speak for myself.
All right. I certainly understand your desire to do those things. The court has to take things in order of how they proceed. Right now, whether you make a statement or not isn't going to change the legal stance of the case, because there's been no evidence produced yet. You are presumed to not have any responsibility until there is evidence of that. This is a preliminary determination at this point. So in a moment, I'll hear what you want to say. The next step is to determine whether or not the petition needs to be authorized or should be authorized, so that the court can take a preliminary jurisdiction in the matter. As to that, Mr. Delaney, as to Mr. Tingley, what is your pleasure?
I've spoken with Mr. Tingley about this case. I don't have a clear picture from the petition what the allegations are. As to Mr. Tingley, it appears to be a housing situation. So once I get more information, so I think I will request a preliminary exam so I have a better understanding of this case. And if the department's not ready, I explained to my client that may be an adjournment, but once I had that information, I can make an evaluation. So I am requesting a prelim at this time.
And Mr. Brown, as to a determination of whether to authorize the petition, what is your pleasure?
Again, Your Honor, I have not had an opportunity to speak to Ms. Radke.
All right. We'll, in order to protect all of your client's rights, we'll indicate that a preliminary hearing is requested at this time. Mr. Sommerfeld, are you ready to proceed on that today, or would you request an adjournment to have the appropriate witnesses available?
I do have the author of the petition, Mr. Burke, here today. It doesn't sound like Mr. Brown, that he's, I think, like fully, if he hasn't met his client, I would not want to proceed under those circumstances. And if we're going to do.
Yeah, I don't feel comfortable, honestly, Your Honor, having this thrown at me last minute. I was completely to make a statement, and I am a firm believer in that my integrity and honesty is everything I have, and I honestly don't need his representation.
All right, Ms. Radke, what statement would you like to make to the court? Anything else other than what you just said?
Buckle up, guys. Today we are stepping into a courtroom that already feels slightly off balance. The hearing opens with confusion, missing paperwork, and most importantly, an absent party who was clearly expected to be there. Despite that, the judge calmly pushes forward, setting the tone that the process will not wait for anyone. You can already sense the imbalance of preparation here, especially when one side admits they didn't even know they had representation. It's subtle, but this moment quietly plants the seed of disorder that will grow as the hearing unfolds.
I have so many things, but to summarize, there's been a lot of concentration on pointing fingers at me and claiming that I am mentally unstable. And I would just beg the court to recognize
Your
patterns.
Honor, I think.
No, Mr. Brown.
Your Honor, I am
have-
appointed, so I would like to speak.
I did not appoint you. I didn't appoint you, Mr. Brown.
Okay, Ms. Radke, the court did, and there's a reason for that. And his concern is that you're going to say something unintentionally that may have the ability to damage your position in the future. And that is a well-supported fear. So if you're going to make statements about the facts of the case, I would caution you about doing that in this early part of the proceedings, because at this point, I haven't even begun to look at the facts of the case yet. We're simply in a procedural process at the moment. The facts of the case will come out over time. There'll be a time in the future for what's called the adjudication. That is a formal decision about whether or not certain things were done or weren't done. Today is not that day. Today, there might be some preliminary facts brought out, and you'll have a chance to argue about those or address those through your counsel. But today is not generally done where the defense or the persons who are accused lay out their side of the story. That's typically not what we're here for today. And I appreciate that that's difficult to wait, but that is the normal process. Is there something other than the facts of the case that you wish to tell me about?
Yes, Your Honor, just to please, I know I completely understand that that is the process, and I'm willing to do whatever it takes to get through this. But I would love the opportunity to be seen in a light that is just someone guilty of having a very human emotion.
Well, Your Honor, again, I don't.
No,
if she wants to,
Mr.
if she
Brown,
wants to-
please, I am not done. I have been silenced my entire life, and this is the most important time in my life, and I really need to make this statement. Okay? I don't even know why you're here.
Ms. Radke, he's here because the court told him to be here, and he has an important role to play. And whether or not you make a statement about what you think is important isn't what today is about. So I'm going to ask you to keep it really short, and I'm going to ask you not to involve the facts of the case. So go ahead.
I won't.
All right. Guys, now the court shifts into formal mode, laying out rights and procedures. But beneath that structure, tension starts creeping in. Everything sounds routine until the mother speaks up, asking for a chance to make a statement. That's where the dynamic changes instantly. Her desire to speak for herself signals something deeper, either confidence or desperation. The judge tries to maintain order, but you can feel the emotional undercurrent beginning to rise. This is no longer just a procedural hearing. It's becoming personal, and that's where things start getting unpredictable.
I would love the opportunity to be able to see my children, because I do believe that my track record of non-violent successful, I mean, goes against everything that is being said about me. So that is the only thing I would like the court to consider today, is to lighten up on the restrictions to my children, because they are the only people that I've ever loved.
Thank you. I appreciate that information. All right, Mr. Brown, as to proceeding today on facts which would allow the court to determine whether or not to authorize the petition, having not had a chance to speak with your client, do you believe that you can do that in a breakout room today, or do you need some additional time to do that?
Your Honor, just given the statements today, I would request an adjournment. It appears that she may want to represent herself, which is a whole different ballgame. So I would like an opportunity to kind of explain to her the process, the procedure, the risks of representing herself in a matter such as this.
All right. I do think it would be appropriate for you to explore that matter with her and help her understand the process in a little more detail, so that she can make it an informed decision about her right to represent herself or her need for an attorney in this process. So for those reasons, I am going to grant your request for an adjournment. Let me ask court staff whether or not we have any idea of when that could be rescheduled. April 28th. Looks like the next available date is April the 28th. What time would that be? We don't know yet. I'm not able to give you a time, so we'll have to set that out in a notice. I know that Ms. Radke is going to be asking, and appropriately asking, to have some contact with her children. Mr. Sommerfeld, or maybe MDHHS knows, what is the current status of ability of mom and or dad to have contact with the children?
Judge, I would ask Mr. Burke, because I don't have an answer to that question.
Mr. Burke, can you answer that for me, please?
Yes. So per bond conditions, Ms. Radke is not able to have contact with Riley, Jordan, or River. There is a parenting time scheduled today with Kenneth, with Riley and Jordan.
All right. And the reason for the no contact, is that because there are pending criminal charges as well?
Yes. So there was a pending criminal charges of domestic violence and third-degree child abuse.
All right. And you have parenting time set up for Mr. Tingley. Is that an
Yes.
ongoing parenting time for Mr. Tingley?
I believe at the moment it is not. It was just kind of scheduled for today.
All right.
Your Honor.
Hang on just a second. Let me finish my train of thought, and then I'll let you intervene as well. What is the thought going forward if we're going to have to adjourn this till April the 28th? We're looking at about a month from now. What would the department believe would be appropriate going forward for Mr. Tingley?
That's what I was going to speak on, Your Honor. You were just
Sorry, go ahead
ahead of
then.
me. No, you're fine. Moving forward after today's visit, I will be taking over for supervised visitation for him. In per policy, that is once a week for their ages. So we will help facilitate that moving forward.
All right. Now things take a sharper turn as the legal side starts showing cracks. The attorneys themselves seem uncertain, requesting more time and clarity, which hints that the case may not be as straightforward as it should be. But then comes the real moment. She openly rejects her lawyer. That's a bold move in any courtroom, and it immediately raises the stakes. It's not just about the case anymore. It's about control, trust, and credibility. When someone chooses to stand alone in a legal battle, it either signals strength or a risky miscalculation.
All right, Mr. Delaney, any objection or any issues with that?
No, I've spoken to my client and I would just recommend he work with the department and with seeing the children. If there's anything that's not working for him, he can call me and we can file a motion to expand any parenting time.
All right, thank you. Any other issues that we need to address before I close the hearing today?
Your Honor, may I say one more thing, please?
Yes.
I'm so sorry. Thank you. If the visits are supervised and we are to proceed under the presumption that I am innocent until proven guilty, then I don't understand. I don't understand
Your
why
Honor,
I would not be allowed
I will
with
call her after court and
a
explain the
supervised
difference,
visitation with my
the
children.
difference between this case and the criminal case.
All right, thank you, Mr. Brown. Ms. Radke, and I can certainly appreciate your concern and your questioning of what's going on because this is a complicated process. There are two things happening at the same time. One is the criminal case, and there is a criminal case order that forbids contact between you and the children right now. And this court can't overrule the criminal court. In addition to the criminal case, there is this part of the case, which is family and children oriented. And that outside of, if there are no contradicting criminal case orders, this court can enter orders as to the children as well. As of right now, I have heard no facts, so I've not made a decision one way or the other than as to what the normal process is to get to those decision points. So Mr. Brown, excuse me, can hopefully explain some of those things in a little more detail to you before we come back on April the 28th and begin that process of making decisions in this case. It's a slow process. I apologize for that ahead of time. But what we're trying to do is make sure that we make good decisions in the best interest of the children at all times and err on the side of being careful while we're doing that. And that may cause the parents some heartache, but in the law's view, it's better to have the parents having heartache than the kids getting hurt.
Absolutely.
So
I agree.
That's where we're at with that. So what we'll do today is I can't give you parenting time right now because of the criminal case status, and we will readdress that in the future if the criminal case status changes, and your attorney can certainly bring those issues to my attention in the future, just as Mr. Delaney can do that for Mr. Tingley as well. So having said all that, we will adjourn today so that Ms. Radke can discuss matters in detail with Mr. Brown, and I'll see everybody back here on April the 28th. The notice will indicate at what time, and we'll do that via Zoom as well. So thank you all very much. That's all for today.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, guys, this is where everything peaks. The mother tries to speak her truth, but the courtroom pushes back, reminding her that timing and procedure matter more than emotion. Still, she persists, and when she finally gets a moment, her plea shifts the entire tone. This is no longer just legal, it's deeply human. Then comes a twist. Serious allegations surface, completely reframing the situation. The judge ultimately adjourns the case, but not before setting strict conditions. What started as confusion ends in heavy tension, unanswered questions, and a clear sense that the story is far from over.